Next, we have somebody that was on our committee. We miss him. He did good work, but it's nice to have him here to present a bill. Assemblymember Anderson. He will be presenting item number 19. Welcome. For the sake of the audience, just so you know, in sign-in order, not that they are all here, but next would be Assemblymember Torres, Assemblymember Rambula, Assemblymember Ruskin, Assemblymember Carter, and then there might be others on the committee that have bills, myself included. But right now we're going to hear from Assemblymember Anderson. Welcome.
Thank you. Mr. Chair, members, Assembly Bill 509 is a measure to clarify the law regarding suspects fleeing peace officers. I am taking technical amendments that will further add clarity to the bill. AB 509 does not increase penalties, but it does lower the cost of trial. With me today is the sponsor of the bill, Glenn McAllister, from the San Diego District Attorney's Office.
Good morning. My name is Glenn McAllister, and I am a Deputy District Attorney from San Diego County. I currently serve as the Chief of the East County Division down there. This bill is intended to clarify some language to bring this section back into the category of an inherently dangerous felony. It adds no new punishment. It creates no new violations of law. From a common sense approach, when you look at the conduct that's involved in felony evading, it requires, under most circumstances, a wanton and willful disregard for the public safety. And in the cases, for example, a case in San Diego that has been reversed because of the Howard ruling, the ruling that this bill is designed to correct, the conduct involved a high-speed chase. Several stop signs, stoplights were run by the defendant. He passed a school bus in a school zone on the wrong side of the road, lost control of his vehicle, and ended up striking and killing two 8-year-old girls that had just been released from school. The conviction was suffered back in 1998, and as a result of the Howard ruling, that conviction was overturned, and we are still attempting to get a retrial of that defendant at this time. What's interesting is that the Howard case, which brought us here in the first place, this bill here in the first place, no one disputes that the facts in that case were horrendous either. It showed a wanton and willful disregard for public safety, inasmuch as several stop signs were run, high-speed chase by a peace officer, and the result was that after running a red light, the defendant struck a vehicle, killed the driver, and severely injured her husband. The Howard analysis that we are here to remedy is simply a legal analysis of the section 2800.2, where it says if the crime can be committed and not be an inherently dangerous felony, then we can't classify it as an inherently dangerous felony. By eliminating the language that talks about being able to be convicted of that section for 3 one-point traffic violations, by eliminating that language, it would then clarify that any violation of this section involves wanton and willful disregard for public safety and therefore is an inherently dangerous felony.
Thank you. Others in support of the bill?
Mr. Chair and members, Corey Salzillo on behalf of the California District Attorneys Association, we're in support.
Thank you.
Glenn.
Tim Yarian representing the Association for Los Angeles Deputy Sheriffs and Riverside Sheriffs Association. For the reasons eloquently stated by the District Attorney, we support the bill.
Thank you.
John Lovell with the California Peace Officers Association, California Police Chiefs Association, and the LA County Police Chiefs Association. Here is yet another example where if you ask an ordinary person, is careening through a neighborhood, blowing through stop signs, going on the wrong side of the street, an inherently dangerous activity in a multi-thousand-pound car. They'll say, duh, yes. This is, again, an opportunity for us to codify common sense. We strongly support this bill.
Thank you.
Ron Cottingham, President of the Peace Officers Research Association of California. Obviously, we need to recognize that the person that is always in control of the pursuit is the suspect being pursued. Their requirement is to submit to the stop and the contact. They're the ones that put the public safety at risk, and in failing to yield, they put the public safety at risk. They also put the safety of our members, our officers that are out there that sometimes get hurt or killed in these same accidents. PORAC is in strong support of this bill and urge your aye vote.
Thank you.
Lieutenant Barbara Ferguson, San Bernardino Sheriff's Department. We're in support of the bill.
Thank you.
Gail Stewart on behalf of the San Diego Sheriff's Department. They are in support of the bill.
Thank you. Any others in support? Any individuals or organizations in opposition to the bill? Please step forward.
Good morning, Mr. Chair and members. Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice. We are opposed to the bill in its original form and also as it's proposed to be amended. And let me just state for the record, I am not opposed to common sense, but what I am here to clarify is that what some of the arguments the proponents made are inaccurate. Let's be clear, this is increasing punishment. This California Supreme Court specifically said that these crimes do not qualify for the felony murder rule. Unanimous. In fact, Justice Brown, who dissented, said we shouldn't even have the felony murder rule. The key to this rule is that there has to be some sort of malice. That's why we want to categorize only those felonies that in every circumstance create a danger to human life should be able to trigger this felony murder rule. Even the proponents acknowledge that, okay, it may not be all the time, it may be some of the time, but that's good enough for us. So we are changing the bar. We're lowering the bar. We already have a statute that says if someone's acting in wanton disregard for human life, you can already get 15 years to life. If a police officer dies, it's 25 years to life. So what we're doing with this bill is saying, well, if you can't prove that, let's go with something lower than that and yet give a higher penalty. That makes no sense. So in some ways, I am advocating for common sense, but more importantly, I'm advocating for legal sense. There's a reason why these cases have been litigated all the way up to the California Supreme Court, and there's a reason why the court specifically said they are the ones that created this felony murder rule, not the legislature, and in fact, the legislature doesn't have the authority to expand it. In fact, the court said, don't expand it, because we've made it very narrow, that only those crimes that we know 100% of the time should qualify for murder, will qualify for murder. This bill goes counter to the California Supreme Court decision. So I ask for you not to support this bill.
Thank you. Any others in opposition? Seeing none, questions, comments from my colleagues? Not sure that I see any. Maybe just if the author is part of the close, either yourself or one of your witnesses can address the concerns just stated.
I'm going to defer to my the sponsor.
In fact, the section eliminates a way to be convicted of the section by eliminating those 3-point traffic violations. It does clarify the bill. It does make common sense to say that when you engage in that conduct, it is inherently dangerous to public safety. And it actually takes people who might otherwise have been prosecuted, though I must say I don't know personally of any time when the 3 1-point violations have resulted in a prosecution under the statute. But it eliminates the possibility that they will be prosecuted and says any violation of this section is inherently dangerous.
Thank you. Anything else you'd like to add to close?
I just want to add real quickly that the court interpreted that the law is ambiguous. The facts of the case were straightforward in many of these instances. There were convictions, there were repeals, and now they're being retried. All the bill does is add clarity to it so that the prosecutions don't have to go through 2 or 3 prosecutions because of how it's being interpreted. If you travel in front of a school when school's letting out and you kill a couple little girls, you should be prosecuted and you should go to jail. And the confusion lies on how to interpret this law. We want to add that clarity. This bill is going to provide clarity and efficiency in the law and justice for the families whose loved ones have been killed. I ask respectfully for an aye vote. Thank you.
Thank you very much. Any other questions, comments? Seeing none, we have a motion by Vice Chair Hegman, second by Assemblymember Gilmore. Let's call the roll.
Solorio?
Aye.
Solorio, aye. Hagman? Hagman, aye. Furtoni? Gilmore? Gilmore, aye. Hill? Hill, aye. Ma? Skinner? Skinner, aye. Bill's out.
Your bill's out. Congratulations.
Thank you very much.